Okay, I had to stop a minute. This whining is making me nuts. Is it just me? Or is him going on and on about his rights just make you want to hurl? Look, the bailiff looks pissed. It's like, what about the rights of all of those people you chose to hurt and continue to hurt in trial? And just, it's just, I don't know. He just, oh my God. I don't know if I've ever seen anyone like him before. Pray we never do see another.
Something upon me, that's coercion, Your Honor.
Coercion.
Mr. Brooks, I completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely uncooperative with court this morning.
That's because I didn't understand. I'm explaining why, Your Honor. I'm not trying to leave it where it was at. I'm attempting to
answer the questions. So
I'm
going to
explain myself of why
we don't
I did
really,
not
we don't
answer.
care. We're done with you.
The way that you're making it seem is that I intentionally didn't want to answer, and that's
Yeah.
not fair.
I'm moving on to instruction.
Maybe it's not fair, but it's true.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
if I'm telling
that's
you
what he
I don't
hopes. He
understand?
hopes that he'll proceed.
I'm asking you to be
No, I don't. No, I
Mr.
don't.
Brooks, please stop interrupting.
And for the record, I don't consent to being called that name, Your
You
Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement. So
Hearing and understanding is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're
Yeah, you are.
At some point, you're going to ask me my opinion of what's going on, and then when I tell you I don't understand, it's going to be taken as me trying to delay or trying to do this or trying to do that.
You're delaying right now.
Why I'm bringing up instruction 315.
And I'm not going to understand your explanation.
Well, you can't say that if you haven't heard what I have to say.
Didn't you try to do this earlier, before lunch?
But I need to clarify something.
Look at him.
315,
tiny little
which
boy.
is the instruction that has it's titled, Defendant Elects Not to Testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There has been no request made. And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
Mr. Brooks, do you
He's
have
going to
any position
disagree
on
now.
whether
Watch.
this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what
okay. He's going to do that.
jury instruction is.
It's entitled Defendant Elects Not to Testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by a defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way, and it must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand
the
what
jury instruction.
Just shut up and listen.
Read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My question to
never say
you
yes
is,
or no.
Yeah, but that's
do
the
you want
problem.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct.
Oh, God.
I'm not hearing a request from you to have the jury
Because
given this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never decided to or not to testify.
Yeah, but because you would delay it forever.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I really do. But in light of the court's decision that you forfeited your right to testify,
how did I forfeit something?
Oh my gosh, she told you already. My
something
God.
to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way.
I don't understand because I never made a decision not to.
You gonna fuck yourself over,
I'll
boy.
ask you one more time.
They
if
don't.
you do not answer
Little
with a
boy,
yes
little
or
boy.
no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your Honor?
you want?
Well, if you're not going to answer her, she can do it.
Instruct the jury in any way regarding you not testifying in this case.
I don't understand the question.
All right, then based
I don't
upon there has
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Well, if you don't understand,
Then I have looked over the verdict forms
Yeah.
and other than really
See,
what I would
he's still
describe as
trying to delay.
consistency in
so
how
disgusting.
phrases, whether there's all caps, not all caps, but
All
what we
caps.
call the sentence
Oh, look at that.
capitalization for the
He
charges.
couldn't help himself. Boy, you are so weak and pathetic.
For example,
He
I want
really
to be
is,
consistent
guys.
with how
So
I spell out
disgusting.
first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I
He's
put
gonna
the
try to
not
participate.
guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case totals 76.
I don't understand.
Too bad.
So how?
I looked at the
You think without you?
special questions
What do you
that
say,
are on
Ryan?
the guilty verdicts only. They did appear to
Mhm.
be proper, again, just some grammatical things, but I believe those are all accurate.
Can I go to the
Return
other
to the
courtroom?
state.
Since you don't have to answer any questions, but I have to answer all, can I just go to the other?
You didn't answer any questions, you
This
asswipe.
time.
Why not? I keep telling you I don't understand these proceedings, and you just keep running right over my rights like you don't even hear me
That's a-
saying anything.
That's a pretty funny figure of speech, running over his rights. Oh my God. How about the people's rights that he ran over, literally? He is, oh my God, guys, I can't, each time I think I dislike him, I despise him even more. He really is out for no one but him. And he just thinks if he doesn't say anything, that means he doesn't consent and he's going to delay. But he's so idiot.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this courtroom?
I'm not waiving anything.
Well, then you're going to have to
I'm
stay.
making a request.
The
Mm-mm.
answer is no.
Then how's it? So
You're not,
what?
you're not in a
You
hotel.
gonna try to force me to interrupt and do all this so you can
Force him to interrupt that.
make it seem like I forfeited something.
Nobody
that I
forced you to
came in
interrupt.
Here, as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that.
Sir, the only one with the drama is you.
It's
Amen.
you too.
Oh my
You're
God,
the
you
big
too.
contributor to the whole thing.
Mr. Brooks,
Oh my God,
I
he
have the
cannot take
right
any
over this
responsibility.
case.
Yeah,
Every-
and you haven't been
everyone's fault.
impartial or fair yet.
Oh, poor thing.
Mr. Brooks, I have a question to the state. I ask that you not interrupt. And
It's not about me interrupting. It's about me attempting to understand. I've been
No,
saying
you
this
are
since we
interrupting.
came in
So
here.
shut the fuck up.
Mr. Brooks, I
You
will
can't
respond
force me to
as follows to
understand.
that. You waived your right to counsel.
I didn't waive my right to no counsel. I
Mm.
gave you the contract.
Right.
I did not.
Oh,
And
yes,
you
you
won't
did.
sit here and say that for the record because that is not
No,
what
you
happened.
have, you
Wow.
are incorrect.
So we don't have the, do we have the paperwork? Because I believe that I gave you the paperwork back that you,
Mr. Brooks, you
I gave it to you,
Yeah,
altered,
nice try.
and did not waive it.
have been presenting a nuanced argument regarding
That is
the right
not
to
true.
counsel
That is not
versus
true.
the right to assistance of
That is not
counsel.
true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully understand.
I disagree with your
I
characterization
disagree with your
of the
characteristics.
right to counsel.
Just quit being a parrot.
You know that you accepted
You
the way that I gave it to
the
you.
entirety.
So you shouldn't have did that if you had
No, you
questions
shouldn't have
of
did
me
that.
not understanding.
I don't have any questions
You
whatsoever.
definitely do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks,
It
you
is
are
also my Fifth
interfering with
Amendment
the
right to
proper
be
and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
And
of the
yet
way
you
you
continue
shut
to
up.
You said
interrupt.
waive. I'm not waiving anything.
Then that's why
Did
you're
we wave
here
bye-bye
until
to
I
you?
make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the finding and hold me
Hold him in
contempt.
contempt. Oh my
Which is what you're
God.
waiting to do anyway. That's why that courtroom been set up the way it has for the whole time. Because
He loves
at
it.
some point it's anticipated that I will be over there. Which is not impartial and which is biased. It's judicial misconduct.
Oh God, you're kidding me.
I stated from the beginning, sir, that the goals of this trial.
So you reading from the paper, or are you reading, or are you just citing what you know?
Number one, sir, is during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made. What is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor?
Oh my
I can't
God.
even put evidence into
Disagreement with the
Oh my God, he's still going on that old stuff. It's over. It's over.
Yeah, but how can I defend myself if I can't even present evidence?
Oh my God, his
Sir,
voice
you
is
have
going
not
up high like a
been
middle
willing to follow
schooler.
the rules of civility
But
and
that doesn't
decorum
have
and
anything
trier.
to do with my
It
evidence.
has
I could have did that
everything.
from the other courtroom too, correct?
Sir, you,
If I can be present from the other courtroom, I should be able to present evidence from the other courtroom as well.
and you, by your conduct this morning, sir, are
I'm
not
saying,
willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
totality.
questions.
No,
Whether
no.
you
Totality.
No.
Have
had
I
a
not
witness
asked?
available.
Have I not asked? In fairness, have I not asked to admit evidence? Have I not asked?
Yes, but it's not.
Mr.
It
Brooks,
wasn't
you have
acceptable.
not
She
asked
already
to
said.
present any evidence
Yes, I
in
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
Oh my
How would
God.
I know that if
Oh my
you
God,
didn't-
please.
if you didn't ask
I
me?
hope she can
That's
get
the
him out
question.
now because I can't deal with it. and I'm just sitting here watching
You
it.
proceed at your own peril sometimes.
That
Whether
has
you have a
nothing to
full
do with me
understanding of the
presenting
rules of
evidence.
procedure and rules of evidence or not.
Ooh,
I
his
made
fingernails
that
are
abundantly
really
clear.
disgusting.
Present evidence.
So, Mr. Brooks,
Nothing
this is your final
presented
warning.
have been able to be admitted into
I am
evidence.
turning to the state for a discussion of the verdict forms. If you interrupt me or them again, then I will make a finding that you forfeited your right to be present,
Make the finding.
and you will appear from the neighboring
And
courtroom.
he's going to
You
yell
want me to appear
contempt.
from the neighboring courtroom?
I don't.
Just let me go.
Attorney Basie, go ahead.
Just let me go.
Mm-mm.
I felt that all the verdict forms looked good. I did ask your clerk.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in recess
wasn't no
until
warning.
this
I'm the one that asked.
over.
So let's
To the other
make the
courtroom.
record.
No,
I'm the one
no.
that came in here, Your
And
Honor.
video working.
No, you don't have the last
I
word.
asked when we came in here to
Mm-mm.
be present from the
We'll have
other
to do
court.
it by Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't understand.
Mm-hmm.
I told you I don't understand.
Okay, just shut up then. Shut the
I'll
fuck
leave
up.
the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
Well, you're trying to control the recess now? Oh, that's amazing. What a piece of work.
Has headphones on. Speaking of headphones, I do need to make a correction to the record from this morning. I had made a statement that given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them.
See, he doesn't listen to all that stuff she tries to do
So we
for
are
him.
discussing the verdict forms.
God.
Go ahead, Attorney Basie, you can complete your record.
All the verdict forms look good. I did notice, I think it was actually created a misspeak. For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet, it just didn't get printed off for me.
We'll make sure that that's there. Any misspellings of any names?
I did not see any.
All right. All right, I did, when we started up the video conference, Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and my word I accepted and returned it for value. And since I'm now in another courtroom, are we going to judge subject matter jurisdiction?
Oh,
We
God.
have yet to prove it for the record.
Shut up.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
Teresa, you had the large packet of verdict forms. What were they, how were they given to Mr. Brooks prior to the lunch break?
By hand to the bailiff and the bailiff
To be- And the bailiffs are confirming that the verdict forms were provided to him on the table.
Maybe if he looked at his
I will remind
papers.
you once again that I do, it is my practice to put all of the not guilty verdicts on top of the.
You know, if the man looked at any of the papers, he might have been able to provide himself with a better defense. I mean, not that he would have done that great, but he's so stubborn. I think he really feels like he is so smart and everybody else is an idiot. So he's not going to read anything that they have. But he could have done a little bit better. But he refuses to look at anything because he's the only one that's right.
Guilty verdicts in a collated fashion. Again, I saw a couple of just cleaning up, I would say, not with the words themselves, but just capitalization of various words within the verdict forms, and I'll make sure that's done.
I'm surprised he
The
has his
appropriate
headset on.
counts
Huh.
had and have the appropriate special verdict questions. Those special verdict questions are only as they relate to guilty verdicts related to the use of a dangerous weapon for counts 1 through 6, the homicide counts, and then 61 through, I believe 60,
It'd be 7 through.
7 through 67 have that special verdict, and then the hit and run counts have
They're not really over his ears, are they? They kind of look on his
special
front of his
question
ears?
related to
His headset?
did each of the counts involve the death
I
of
don't
a
know.
person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed, going back to the jury instructions 315. We have done a little bit of rearranging some of the order, but the content is there. It is my practice to read through all of the instructions up until the point of closing arguments, and then I stop. Parties are given their opportunity to argue the case to the jury, and then following that, there are what I like to call the closing instructions, or which are still quite lengthy in this case, given that they go through the verdict form specifically. And then, of course, the alternate jurors would be selected. But given...
Am I muted?
No, you're not. You haven't been.
So I got a question about the hazard for use of a dangerous weapon. How is that being charged? Is that under 939.632?
It is in the charging document, sir.
How is that being charged? From my understanding, that the statute reads the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State want to is your
Right.
argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree recklessly endangering safety charges, so counts 1 through 67.
Mm-hmm.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah. How is that?
I'll get right back. Isn't it interesting? I thought he didn't understand, but now he's engaging in whether he really understands. But he just couldn't shut up. He couldn't do it. He couldn't do it. All right.
The alleged defendant being charged.
So are you asking how are you making a specific request as it relates to the special verdict question?
I would say both.
Mm.
Seeing as how I don't understand how.
Mm-hmm. You understand enough to ask about it, though, don't you?
That's the question.
Mm-hmm.
Reading the statute.
And which part of this, I'm sorry, which part of the statute are you referring to again?
I believe it's 939.632.
Mm-hmm.
Your specific argument is what again?
How is that enhancement? How is the alleged defendant charged with that enhancement when reading the statute it says it? Well, I just read it, so.
Mm-hmm.
I believe you're referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Right, that's what I just read.
Mm-hmm. And?
Well, what's the state's response?
Using,
possessing or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes. That's not what the statute is clearly saying.
Clearly.
Stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime?
I think you've said it like
so it
3
has
times.
to be an essential element of the crime. Otherwise, there's no crime.
Oh, come on.
I think it's the essential element. If you read in the statute, it's the essential element. You can't just walk up to someone and quote unquote run them over.
Well,
There has to be something used in order for this alleged crime to transpire, and that would
your foot on the accelerator?
be the quote unquote dangerous weapon. So without the quote unquote dangerous weapon, where's the crime? So how can it be charged?
Okay, he said it over and over. Could somebody please interrupt him?
Essential element of the crime charge.
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first-degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon. And so
that's the same argument in this, Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same thing.
it's not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
I respectfully object to that, Your Honor.
Of course you did.
Understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
Yeah, would that be, will my objection to that be noted for the record?
Okay.
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there.
Nice.
That was provided to me by the bailiffs.
May I respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal
Oh
on this
God,
matter?
it's the
It's
same
not the
shit.
proper court to grant such relief.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction
Your request is denied.
based on what law or fact?
Your request is not based in law or fact, sir.
I just stated I just read a statute that it came from. My
Mm-hmm.
argument was based on a statute,
I thought you didn't
a
understand.
Wisconsin statute.
I think you still don't understand, but nice try.
Your request is noted. Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter?
The court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony.
Which was not,
I'm not going to
which was
revisit
not
the same.
which was not consented to. I never stated that I did or did not
Understand.
testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination?
Oh,
that you don't have to
God. Just
these
answer a
questions?
question, fool.
I'm not answering those questions, sir, other than how I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
Mm.
Sir, I will ask you once more, do you have any other issues?
And I will
To
tell
raise
you once more, I
with-
don't understand the questions that you are asking.
Sir, do
So
you
I
have
will-
any other issues to raise with respect to the verdict forms?
I do not understand
Mm.
the questions that you are
He
asking.
has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have
Under
any
what law of
additional?
fact? Under what law of fact can you
Oh,
say no?
shut up.
When I'm
Sir, do
telling
you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that
respect
is incorrect.
No,
to the
you're
verdict
incorrect.
forms.
That is incorrect. I stated I don't understand. You
Mhm.
can't force me to understand something. Your Honor.
Yeah, she's
All
not.
right, did the state have any
It is-
other?
It is my
I want to mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow. So I exercised my ability to press mute. Does
Jesus.
the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
We do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates to the jury instructions?
Yeah, I have questions related to all of them because I don't understand.
Mm-hmm.
My question was not, do you have questions, but do
And
you
my
have any
answer
requests?
was, I don't understand.
Okay, then just turn him off. Say bye-bye.
And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is choosing not to answer my questions.
You did not.
I'm going to mute him momentarily, sir. I will ask you one more time if you have any requests as it relates to the jury instructions. I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions, I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates?
You just said you was referring to the filings, right? Did you just say that?
That's not what I said.
He's such an ass.
Did you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific filing you can refer the
Boy,
court
he's
to
such an
that
ass.
relates to jury instructions?
So is your computer working or is it not working?
He just acts like he's so casual
I'm
and
a little
comfortable.
temperamental, but I just can't use my search function. So if you can direct me to a filing, that would be great.
Oh, you know what? Because there is no filing. Watch. Just watch. If he I can't wait.
It would also be great for those filings to be admitted into evidence.
Jesus, man. I'm sorry.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me to make all my filings in writing.
Sir, I said if you had
Yes.
a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
That doesn't mean it was
Sir,
going to be accepted.
what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have something in particular,
Wow.
sir,
I asked you to do your job.
sir, if you have something,
your
a
job?
specific request,
Oh my
now
God.
is the time to make it.
You know what? He's acting like she's, I don't know, his servant. Do your job. Gosh. His detest for women is so evident. I hope that Bubba Boo is roughing him up a bit. It's just disgusting.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this?
Why do we have to keep hearing you say that? I don't know why it's blurred, guys. Let me see.
Then I can report the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September.
Who gives a shit? You still had time.
There was documents that I didn't even know that existed.
Mr. Brooks, one final time, do you have any specific requests as it relates to the jury instructions other than your
He's
request
just
that they
pulling
all be
her
struck?
damn chain.
And I'm telling you, Your Honor, I don't understand the question.
Oh my God.
I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they
Okay,
will
no,
get
and then-
approved.
Well, then you don't have
They will
any.
be approved
Shut
and are-
up.
I'm gonna have to mute
No.
him.
Yep.
They are approved as been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct.
Wow. He's something
And
else.
provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just
He's not
noting
even
there's
wearing
just a
those
few grammatical
properly.
things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the
He's the
parties this
oath of
afternoon.
office. I hope she doesn't unmute him anymore. She probably will have to.
I believe that the
Ugh.
final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any
God.
statement?
I don't understand.
I don't just understand calling that name, and I've just told you I don't understand these jury questions. I'm not going to know how they allowed to pass just because you feel that they should.
Wow,
I'm
she's the
telling you, I
judge.
don't understand them.
Doesn't matter. She's the judge.
I would note that his
Not one of those jury instructions came from me. Not one. How's that fair?
Oh, it's not
Mr.
fair.
Brooks, this court gave you the draft of the jury instructions. I need to mute you because, once again, he's debating about things that I think are very clear on the record. This
Of course.
court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to
Oh, yeah.
jury
Just
instruction
just take them off if you're going to wear them like that. You
and,
look like an
The
idiot.
state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication.
He looks like a
forms
damn
that have
fool.
been
I'm
sent
sorry.
during
You
this
just,
trial
no, I'm not
that
sorry. Why do
are
I
on
always say
file.
I am
haven't
not
seen
sorry.
anything that references jury instructions.
No, he didn't do
I'm
anything.
well aware that he has other filings,
Oh, yes,
but
I'm
I
sure he
could
is.
not find
No.
anything
He's just talking out of the side of his
related
neck.
to jury instructions.
No.
And any specific requests
He's just
that
making
he's
stuff up as it goes.
making or made
Doing it badly, too.
during
Sorry.
this
I'm
case.
talking over her. I apologize.
So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper, in terms of scheduling.
Yeah,
And
take them
I
off.
would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up. I think it was the alternate sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the three alternates once they have been selected. It would be our request, the position, that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case. So that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are deliberating, if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that.
Oh, brother.
Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you since nothing I say even matters at this point.
It really doesn't, but they have to pretend it does. You know what I mean?
I'm just gonna tell them the truth.
It doesn't matter.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I base them on.
Oh, he's so slick.
Well, I trust the state will object when appropriate,
Well,
if
There's gonna
appropriate.
be a whole lot of objections then because I'm gonna tell the truth. You haven't
You don't even know the truth,
You
dude.
just been making all the decisions for me. Even
Oh,
though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm
No.
telling you I don't understand, and you still make a decision determining
Oh.
my life.
oh. You made your
Are
own
you telling me,
decision.
sir, that you will refuse to follow the simple rules of decorum, courtesy,
It ain't-
civility,
don't-
the rules of
don't
evidence,
try to
and
come- don't try to
the
come with
rules
those
of
slick
procedure?
words. Don't try to come with those slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You
preserve the
you've been
integrity.
you've been slick. You've
All
been
right.
slick.
Wow.
I'm gonna mute you, sir, since what you are saying is not productive. It is not courteous.
Watch him. He's
It
going
is
to throw him. Look at him.
disrespectful.
I don't care
I
what
need
you
to
think.
I need to go
I
over
don't care
these.
what you think.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument, and so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments. Madam Clerk, can I see the instructions that we have thus far? The packet? I just, okay, thank you. Single side. So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning. Because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, and to highlight the important points.
Yeah.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yes. Yeah. How many people actually live by it, though? Anyway.
Oh, and he thinks he does?
Sir,
Wow.
I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Well.
Then you'll forfeit your right to give one, sir, because as we have...
You can't force me.
He's just trying to hold it up as long as he can.
You can say you're going to force somebody not to be able to give a closing
What a
argument.
cruel thing to do
Sir, if you
to the victims'
choose not
families.
to give one,
How's that lawful law?
sir,
Wow.
if you
He's
choose
such
not
a child.
to give one, you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead.
Incorrect?
Go ahead.
I'll mute him once again because
He's
clearly
correct
he
about it?
just wants to be disruptive this afternoon.
God,
But
yes.
as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. You know, if it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I've really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I
God.
can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws they don't agree with.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. You can't, so you added these jury instructions at the last minute. You should have never.
Oh my, at the last minute, my ass.
I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear
Yes.
to me you've done your homework.
I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented, and those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir.
Oh my gosh. He's such an ugly human
With
being.
that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover their verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I am contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well.
Nobody gonna be here.
Even if I consider kind of,
I said nobody gonna be here, like I'm there. Nobody's gonna be there.
Away. So that's my initial
Nobody will
thought on
be there for
that.
him.
Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the state for victims.
Okay, and the other side,
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think
previous, or my rule throughout has been 15 minutes. What I would say is any open seating will open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay.
If that's what you're asking me.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but I don't. How can you deprive me of my constitutional rights? How can you trample on my constitutional rights?
God. How could you trample over people with the wheels
Sir,
of your mother's
you
car?
forfeit a number of constitutional rights by misconduct on your part.
Not if I reserve my rights. You can't reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
going
versus
to do that.
Arkansas, State versus Anthony, Illinois
Did they
versus
reserve their
Allen,
Did they reserve their rights?
the Benevue decision. There's a host of case law, sir.
Got that patch of hair. The front looks
All right, sir, you are
ridiculous.
simply mistaken on that. So I'm muting him once again. He's not giving me any other issues
No.
to address.
No. Except
We
him.
are in recess.
Oh, I'm sorry, I have a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yeah.
sorry. Go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury instructions? Okay, it's just the jury instructions, but thank you, because I didn't see
He
that.
is
given
so
some of the things I was
freaking
looking at,
creepy.
so I appreciate that.
Were all jurors
Yeah,
or will
she
all
told on
jurors
you.
then be told to report with an overnight bake?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell. I see your arms waving, I'll get you in a second, that he's
God.
provided with that as
Do
well.
you have to?
Alright.
And you as well.
Oh my
And then one
gosh.
final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes.
I don't think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get to you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make you look bad, I think we should say for the record that one of the rights I have is to demand that the court place in the evidence any unrevealed contracts, statutes, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what case law says you have a right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Oh my God.
So that is very general, your statement. It's vague. There's nothing
So we don't
specific
know what-
you have
what
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires as well.
Yeah, let's put it in the trash.
I
Guys.
accept for value in return for value any documents,
I hate when he says all that stuff. Good God.
since, it might be another record of what I'm doing, since it's always a record of what I'm doing.
Well, yeah, you're damn right
And
there
I
is.
also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the black,
Oh my God.
it's some explaining that needs to be done. That is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms
Look at that.
to give.
Lou, he looks so
If it takes us longer than
maniacal.
30 minutes, we'll make sure
That's
that
very
the verdict
chilling
is
right there, how
sealed.
he's looking.
Thank you, everyone.
Thank you.
He's so proud of himself. Nobody can hear you, thank God. He just can't wait to mess things up. I'm just hanging on. Sometimes the sound is still on or something, so just in case. Okay, well. So, there we go. Oh, God, that got me all, like, I started getting all agitated and hot and just so, makes me so anxious. But, nonetheless, there it is, folks. Oh, my goodness. So, there's no words. I think y'all get it, though. So, I don't know. I might stop at this point and go back, and then, like, to save that for the end when I get all finished with this, which will take a while because we still have many Brooks moments to roast. And so we can, I don't know if we'll ever be able to get him out of our system. But anyhow, look, there's that eagle. Oh, my goodness. Good God. What a freak. So, thank you all for watching. Be kind to one another. Be kind to you. Love you. See you the next time.